The next case is Joseph Ferriot versus Alicia Noga. I guess only the appellant is arguing, so if you're ready, you'll get
Yes, Your Honor.
your 15 minutes all in one fell swoop.
Thank you, Your Honor.
You may begin.
May it please the court, I'm Joseph Cajun. I represent the appellant, who was the plaintiff, and the father, Joseph Ferriot. The T is silent. Your Honor, this case presents an issue of how do we determine who is a child support obligor, where both parties are the residential parent, they have equal parenting time, and their incomes are different. One makes more than the other. The facts of the case are relatively straightforward. It was an unmarried parent's case. They have 2 children. An administrative order was put in place for child support prior to any rights being established, and the parties had worked their own parenting plan without any court intervention until father filed a complaint to establish parental rights and responsibilities. Pursuant to that case, the court adopted a shared parenting plan in April of 2015 that resolved all of the issues from that complaint other than child support. We had an evidentiary hearing on child support, began in February, one day in February and one day in August. So there was a gap in the actual hearing itself. And the order for that came out October 6th. Father objected. The trial court ruled on those objections, and this appeal was taken from that. The rule we are looking for in this case is one it's sort of been an unstated rule that the courts have been applying throughout Ohio. It's a 2-part test, and we see domestic courts using it, and we see appellate courts upholding it without ever stating the full rule. The rule seems to be 2 parts. The first being, first we're going to look at the amount of parenting time each party has. And if the times are different, the party who has less time is going to pay child support, be the obligor, and the person with more time is going to receive and be the obligee. That's easy enough. The second part, of course, becomes what do we do when parenting time is equal? When parenting time is equal, the courts have been looking to the incomes of the parties. And when those are sufficiently different, the person who makes more is the obligor, the person who makes less is the obligee. Of course, in this case, the facts were both were the residential parent, legal custodian, pursuant to the shared parenting plan. That shared parenting plan provided that both had exactly equal parenting time, and using the trial court's numbers for income, even though we don't necessarily agree with those numbers, using them for this purpose, mother makes more than father by about 1/3. So the parties have disparate incomes, and the mother then should be the obligor. For that reason primarily, although I know I mentioned other things and we had other assignments of error in the brief, we'll focus our time primarily on that issue. A second, we'll focus on the reality that the lower court in this case was deceived by the other team, and that a de novo review would have caught some of that deception had they done a de novo review of the magistrate's decision. And if there's time left, we'll discuss why it is we feel that father's income was improperly calculated, although the practical result of that is fairly minimal. So we'll talk about that if we still have time. The first point is really that under the 2-part test, they've been applying this test already, and we see it applied in several appellate court cases. The Warren versus Warren case out of the 10th District, which says that given equal time, even a non-custodial parent can be awarded child support. So they took a case in which the trial court had said, you have equal time, even though you're not both custodial residential parent, we're going going to give child support to the person who makes less. That was an example of this rule being applied at the trial court level, being affirmed at the appellate court level without the appellate court ever actually stating the full rule. And the same is the case in Prussia versus Prussia in the 6th District, Cannell versus Cannell in the 8th District, and Fry versus Fry in the 3rd District. So it is a rule that's being applied around, and a lot of us domestic practitioners know this rule. The approach of it is very logical. It follows an assumption that the parent who has the children will be incurring the expenses of the children during the time that they have them. And thus, more parenting time equals more expense, less parenting time, less expense, and the party with less time should therefore chip in to the party with more time. When the time is equal, it's really looking at the child's best interests and saying, we don't want a child to live two separate lives, two houses, a rich house and a poor house. And where the expenses are going to be the same, where we have disparate incomes, we ought to lessen the effect on the child so that they live as even a lifestyle as possible as they travel between homes. And that's where the second part of the test comes in. For that reason, Your Honors, we're asking that this court reverse the trial court, determine that the mother should have been the obligor for child support, remand for a child support order consistent with that result, and also to officially adopt the unwritten rule that domestic courts have already been applying. Using that for this case, the magistrate's numbers said that father makes $20,000 a year, mother makes $30,000 a year, which is a difference of 1/3. Under that test, we believe the mother should have been the obligor. Now, the trial court obviously did not do that. We find that the trial court's order affirming the magistrate's decision really shows that they did not conduct a de novo review. And they relied on a lot of unsubstantiated claims from mother's brief in opposition to the objections, in which she had uncited statements that weren't based on the record, contained no cite to the transcript. For example, the trial court wrote in its decision that as the magistrate found, father's business and tax records are not a model of clarity. Well, first, the magistrate didn't find that. That was not in the magistrate's decision. The magistrate stated that father is self-employed, period. His financial records are very complex, period. And then she states what his income should be. Never does she say that they're unclear or confusing or deceptive or anything of that nature. Second, there seems to be a sarcasm to the trial court's order there, and an implication even that something is going on with father's income. But neither of them actually say that. There's no statement in either the magistrate's decision or the trial court's decision to say that father's income numbers should be different. This only makes sense, and this tone makes sense when you read the brief in opposition that mother's counsel filed. In our opinion, it acted as a fraud upon the court, and as examples, that brief cited that father pays his current wife 3 times his own draw from his company. Well, that made it into the trial court's decision. And that showed that they did not review the record, because the record contained no such information. The record contained that wife makes that amount, but as a manager at hamburger station, not working for husband at all. The only place they could have gotten that information is from the brief that mother's counsel filed, which was uncited and unsupported. And further, what makes it a little worse, in my opinion, is that mother's counsel at the evidentiary hearing submitted father's wife's W-2 as an exhibit. So they knew that wasn't true. They deposed my client's wife, and they talked to her then about what she did for a living and how she was paid. And so it took the shape of forming this picture of father as someone who's essentially paying all his bills out of his business, and that just wasn't the case. There was no such evidence. Next, the brief cited that father had $260,000 in deposits into his bank accounts. That number was never mentioned in any evidentiary hearing. There's no citation to it in their brief. And one of the things that's interesting about that one, what makes it worse in my opinion, the magistrate took all of the exhibits offered by mother over objection. She took them into the file and ruled on them in her decision only, but they made it into the file. Paragraph 17 of the magistrate's decision states that Exhibit W will not be admitted as evidence. Exhibit W offered as proof the total deposits into all of father's bank accounts, which mother's counsel had every bank statement relevant. What they did was had mother herself personally count the deposits in all of his bank accounts, business, personal, or otherwise. But they didn't exclude transfers between accounts, so savings to checking, checking to savings, business to personal. They didn't exclude any of those. And although they put $260,000 in their brief, their Exhibit W only said it was $107,000. That was a serious problem, a serious deceit upon the court. It went to painting this picture that he's hiding money, that his income is truly higher. They said the father pays the mortgage, the gas, the insurance, all out of his business accounts. It's not true. It wasn't cited. It's not in the record. So the magistrate's decision and the trial court's decision read very differently. The magistrate's decision simply decides the income, sets the support, and although it doesn't say why, it makes the father the obligor. It makes the father the obligor. The trial court's decision, on the other hand, is tainted by that mother's brief. It has a sarcastic tone to it, and you have to read between the lines to figure out why they made the father the obligor. It seems to say that he's trying to hide income or making more money, but it never actually says that. It never actually puts that on the record. And so it states no reason at all why father should be the obligor in this case. To us, that's a real problem. Under the two-part test, they should have started with he's the obligee and she's the obligor.
You have 2 minutes.
Thank you, Your Honor. In conclusion, boiling this case down to its actual facts, which were actually on the record, it's not a particularly interesting case. Father is mows lawns and plows commercial driveways for a living. It's not a cash business because it's commercial clients. All of his records are actually pretty clear. His CPA testified. So what we boil it down to is we have 2 kids. We had equal parenting time. We had both with a residential parent, and mother makes more money. That's the only finding of fact the lower court made. Under those facts, the mother who makes more money should be the obligor, and the father the obligee. Beyond that, this case became muddled and confused by a lot of misinformation provided by mother, a lot of non-evidentiary exhibits that were taken in by the lower court, and a brief that frankly was deceiving. For those reasons, we ask this court to reverse the lower court, to determine that the mother should have been the obligor and adopt the two-part test as a rule, remanding for a child support order consistent with that decision. Thank you, Your Honors.
Thank you. Have a good day. We will issue an opinion, and it can be also found on our webpage if you want to look.
Thank you, Your Honor.
Thank you.